All rise. The Court of Appeals Division 1 is now in session.
Thank you. Please be seated. Good morning. This is the time set for oral argument in our cause number CV130558, Bond Safeguard Insurance Company versus Santan Borgata Development et al. Counsel, we are recording today's proceedings, both audio and video recording, so when you step to the podium, if you would please identify yourself and the clients that you represent. Each side will have 20 minutes for argument, and appellant's counsel is responsible for watching the clock and reserving any time for rebuttal that you might desire. We have read the briefs, we've conferenced the case prior to argument, we believe we understand the facts and the procedural history. So with those preliminaries, counsel for the appellant, you may proceed.
My name is Wayne Ducharme from the Ducharme Law Firm representing the appellants. There are a number of appellants, so throughout this proceeding I'll just refer to them as Santan Borgata, who is the prime appellant. There are two main issues that I'd like to present here today in this argument, but I'd like to reserve about 3 minutes for rebuttal. First thing I want to note that a very important party is not here today, and that's Pinal County. And that's Pinal County who was the recipient of the subdivision bond, which is the subject of the underlying litigation. I assume that they were satisfied or not appealing the discharge of the bond by the trial court on equitable grounds. But I expect that Bond Safeguard, in some regards, will step into the shoes of Pinal County and make some arguments on their behalf in order to justify their continuing, or at least their continued attempt to collect bond premiums. The two main arguments that I will be discussing today is one, the date of the bond cancellation. We believe the bond should have been canceled at a date earlier than what the court did. And the second main area of inquiry is the Bond Safeguard's breach of the implied covenant of good faith and fair dealing. And we believe as a result of the actions or inactions of Bond Safeguard, that excused any obligations of the appellants to continue paying bond premiums. I think there's critical facts in this case which are very similar to Coconino County case that this court recently decided. As a condition of subdivision plat approval, Santan obtained a bond from Bond Safeguard as assurance to construct improvements for the subdivision. Prior to any construction that took place, the property was lost in foreclosure. No homeowners, no lots sold. The Pinal County did not call the bond. Pinal County did not determine that Santan Borgata was in default of its bond. On the other hand, Pinal County, at our request, would not discharge the bond, would not release the obligations of the bond, but we had to go to court, and on equitable grounds, the trial court said, this is not right, you can't have the bond for the benefit of new property owners in place for years, maybe up to 20 years, the trial court said, and so they canceled the bond in February of 2013. I would just like to summarize for the court the reasons that the judgment against Santan Borgata for bond premiums should be vacated. 4 reasons. Number 1, the bond became moot by operation of law. 2, Santan took actions to cancel the bond. 3, Santan's obligations to pay bond premiums were discharged by supervening impracticality and frustration of purpose when it lost the property. In other words, it couldn't develop the property because it didn't own the property anymore after the foreclosure. And the 4th is, as I mentioned before, the Bond Safeguard's breach of the implied covenant. So there's very little guidance in the subdivision statute for bonds. In 11821, there talks about the necessity for having a bond from a developer for site improvements, but there's no indication in there how the bond is canceled. And if you go to the regulations which were adopted by Pinal County, essentially adopting the statute, they have provisions in there for assurances, one of which was providing a bond. But there's no provision there for canceling the bond except unless the improvements have been completed, and then through a process there is for canceling the bond. But there was no procedure when a developer loses the property in foreclosure. I think that there's 4 reasons or several reasons for cancellation of the bond on February the 20th, 2010. That is the date when the 2-year limit on constructing the subdivision improvements had occurred, and the default was effective on that date. And on that date, the bond was not called, nor did Pinal County consider or notify Santan that they were in default of the bond. February the 20th is the date when Pinal County exercised its discretion not to call the bond, and February the 20th, 2010 is also the date that Santan terminated the bond with bond safeguard. As an alternate date, the bond should have been terminated no later than November 10th, 2010. That is the date of the foreclosure sale in which Santan no longer had any financial interest in the property, could no longer be a developer, and had no access to the property in any way.
Counsel, let me ask you, you're
Yes.
talking about sort of externalities to the contract, right? What sort of happened quite apart from the contract terms that should, as a matter of law, terminate the bond? Is that fair? The 2 dates you've described?
The dates that I described were dates that, right, they weren't part of any contract. They weren't part of any statute. I think that's one of the problems with the statute. It doesn't really define when a bond is canceled.
Well, and I understand that.
Yes.
And that problem, though, could be resolved by contracting language, correct?
In what way, Your Honor?
In the bond, the terms of the bond, when it terminated, what acts caused it to terminate, things like that. In other words, you have, I think, absolutely correctly described that there is no statutory or sort of regulatory impediment that helps anyone decide when a bond terminates. I
Correct.
think that's your argument.
Yes.
But the bond is contract, and couldn't the contract itself describe when its obligations ceased?
On the bond itself, there's no termination date.
Correct.
The bond document itself.
Right.
If you're asking about the underlying general agreement of indemnity, that provision says when the bond is terminated, you no longer have to pay bond premiums.
But these, at least in theory, could be negotiated, couldn't they?
Not so much in theory. These are like form contracts. You know, it's like insurance forms. It's not something you negotiate between an insured and an insurance company. And the bonding company, they are an insurance company. They write the bonds. They write the language. They write the language of the general agreement of indemnity.
And do they have riders on occasion?
Not riders, no.
What, do they have?
Counsel can better answer that question, but I've not seen riders.
My point is, is when a bond terminates something that could have been resolved by the language of the bond itself?
I don't think so, Your Honor, because the bond is required by statute, and you can't make arrangements outside of the statutory requirements when you cancel a bond.
And I understand that, but we're now in kind of a loop because if it's required by statute, but you're saying the statute doesn't provide what sounds like a pretty essential term when the obligations end and when the corresponding premium payment obligations end.
Yes, I think. In looking at it, the way the bond should be canceled or the timing of the canceling of the bond is when the purpose of the bond no longer exists. And if you look at the statute, the purpose of the bond is to assure or guarantee that the improvements will be built if, in fact, there's a subdivision that's been developed or improvements have been started. But when that purpose no longer exists, there's no need for the bond.
Who is the beneficiary of the bond?
The beneficiary of the bond would be Pinal County.
And could, from their perspective, could they reasonably think, look, we just want to make sure we're made whole, whoever does this?
Well, what their argument was, and they're not here to make that argument for themselves, but what their argument was, well, we don't want to cancel the bond. And we talked to one of the supervisors and said, this is ridiculous. The bond just can't go on after you lost the property. He talked to the other two supervisors and they said, well, it seems ridiculous and absurd that the bond would keep repeating and renew year after year after year when there's no development taking place. But they talked to their county council and said, well, let's just leave it in place. No, there's no harm to us. Keep it in place. I mean, the court saw the discrepancy there where we had to continue or pay bond premiums that wasn't doing any value. The bond's been canceled. There's no harm to the county now. The county's going on without any concern about this bond having been canceled by the trial court. They didn't even appeal it.
They did not cross appeal. That's exactly right, and that issue is not in front of us.
That's right. Yeah, they didn't. So they did not object to the cancellation of the bond. In fact, the trial court asked counsel for the county, can we cancel the bond? He said, yes, you have the right to cancel the bond. In fact, in our discussions with the county and trying to get the bond canceled and with their county council, they said, we don't want to cancel the bond. We want a court to tell us that the bond is canceled. And so the trial court did that. And they did it on an equitable basis, but we think there should be another date. There should be a firmer date. There should be a date that other developers can look at and say, well, we lost the property in foreclosure, and as of the date, we have no interest in the property, and so the bond should be canceled because it no longer serves the purpose.
Counsel, let me ask you a question about
Yes.
that. You talk about that it's canceled because there was a trustee sale.
Yes.
Well, what about the scenario where a developer goes in and finishes half the improvements, defaults, and then there's a trustee sale? Isn't that the very purpose of the performance bond, is for the county to be able to call that bond and finish those improvements?
Absolutely.
So the fact that there was a trustee sale, that the developer lost the property, clearly cannot be grounds for canceling that bond. Because in most situations, that's the very scenario that the bond is meant to protect against, is that the developer, for whatever reason, walks away and in fact loses the property.
Exactly, Your Honor. I would make the same argument that you're making. The difference in this case is similar to Coconino County. There was no lot sold. There was no obligation. None of the improvements were started.
You're talking about the Ponderosa case.
Mm-hmm.
Well, in that case, though, the county wanted to have the discretion. There was the original developer who defaulted, never sold any lots, never started any construction. A new developer came in. The new developer wanted the county to call the bond to get the improvements completed.
Yes.
And the county said, well, we want you to pay for some of those improvements. And so that decision held that the county has a discretion not to call the bond and to engage in negotiations with the new developer to see if the new developer will pay some of the costs. And so I mention that because couldn't another reason why the county didn't call this bond is it was holding this bond so that when the new developer came in, that bond could be used to defray some or all of the costs for the improvements with the new developer? There may be more than one reason why the county didn't call it or discharge it.
Well, I think, Your Honor, the difference and distinction in this case is there was no development. There was no start of any improvements. In your hypothetical and so on, where there was improvement started, obviously they can call the bond. And there's cases that say it's a forfeiture to take the money. In fact, the trial court asked counsel for bond safeguard, can they call a bond and put the money into their general fund? No, they can't do that because the purpose of the money is only to complete improvements that have been started. If there's no improvements to be started, it goes back to the interpretation of the statute that was called an absurd interpretation of the statute in Ponderosa.
Let me
Yes.
ask you this. Is it necessarily that the improvements have to be started? Let's say a developer walks away. We don't think this is profitable. We're going to walk away. We want to cancel the bond. And now under the bond and under the indemnity agreement, can they do that?
Those are not the facts of this case.
No, well, I know they're not.
But can
That's
they
the
walk
case.
away and not pay the bond?
I'm saying it's not necessarily dependent on whether construction has been started or not.
I think that's a key. That's a key idea in the cases that I've read, because the bond is for completion of the construction. If there's no construction started, there's nothing to complete. And as even the court said in Ponderosa case, you're not gonna build today improvements for You may not sell the lots for 6 years or more.
But Ponderosa was talking about whether the court had a mandatory duty to call the bond,
Yes.
or whether it had discretion.
I understand that.
That's kind of a different scenario. The issue was not raised whether the county abused its discretion in refusing to call the bond, whether that decision was arbitrary or there are reasons for it.
Yes.
I asked you the question about the abandonment and walking away before any construction has been commenced, only to illustrate that I don't know that the sale of the property by operation of law cancels it, because we certainly can see a scenario where a developer is halfway into the project and then they default and the property sold in a trustee sale, and you'd still be able to call the bond. And I think there may also, counsel, be a scenario where a developer just abandons a project, there's a bond out there, and the county could still call the bond, even though there's been no construction. Or do you not think that the county could call a bond under those circumstances?
No, I don't think the county could call the bond, because when a new owner takes over, the Department of Real Estate requires them to get a new approved plat and to provide the assurance for the property development. They have to provide the assurance, the new owner of the property. What you're suggesting to me is that if a developer still owns the property but has just decided not to develop it, he still has the capability to develop it because he has an approved plat. In those circumstances, I would say yes, that the bond is still in place and he has to keep it in place until he's taken some action to transfer the property to a new owner or some other aspect of it. Does that answer your questions? All right, then I'd like to spend a few minutes dealing with the breach of the implied covenant of good faith and fair dealing, because that is the second issue, and I'm down to about 4 minutes, so I may use up all my time on that area. And Dodge versus Fidelity and Deposit Company, that is Arizona Supreme Court case which set forth the requirements of the dual obligation of a bonding company, both to the, let's say in this case, Pinal County, and also to Santan Borgata. They have fiduciary duties to both. So that as a guarantor, if the development is not completed or if the improvements are not made, then they have an obligation to pay for those improvements. That's their obligation. They have an obligation of fair dealing to the person who bought the bond, in this case Santan Borgata, the principal, to deal with them honestly, to deal with them in a fair way, not to argue against them. In fact, in this case, I know that we discussed the issue of whether improvements were made or not, or the status, but they continue to argue throughout their briefs that improvements have been started, and on that basis, and on some cases cited in other jurisdictions, that we were obligated to pay the bond, when in fact, the evidence is that there was no improvement started. There was no development started. So they're arguing, they have been arguing directly against the interests of the bond principal. For example, say, well, we have liability. You know, they can call the bond. The Pinal County can call the bond. In fact, they almost wanted Pinal County to call the bond so that they can go back to the indemnitors to collect the money that they may have to pay it out. That is the big difference in a bond versus insurance, because under the agreement of indemnity, any money that the bonding company has to pay out, they collect that money from the indemnitors, and in this case, there's a long list of indemnitors. So there are a lot of duties and obligations of a bonding company towards its bond principal, not just the beneficiary of the bond, in this case, Pinal County. Now, we think they breached that. And I have a list of, they failed to conduct an adequate investigation. That's one of the primary positions or arguments against the insurance company or a bonding company. They failed to conduct an adequate investigation. I believe they failed to look at the legal position to cancel the bond. The Lexon case that they cited in their brief, the Lexon case, the Lexon is an affiliate of Bond Safeguard. And in another case, in another matter, in North Carolina, they argued against calling the bond after the property had been partially developed. They said, no, because, as you suggested, there was a foreclosure of the property, so they were relieved from obligation to pay for the remainder of the improvements. The court said no, because the improvements have been started. In that case, that you're obligated to pay for the completing the improvements. They're arguing the opposite in this case, They're saying you're obligated to pay for the improvements even though none have been started. So they're hypocritical in that regard, Your Honor, and they know the law. This law firm and the counsel here is a very knowledgeable surety bond counsel. And there's no evidence that Bond Safeguard tried to work with Pinal County and Santan Borgata to work it out, to discharge the bond, to come to some kind of an agreement about whether we can cancel the bond and under what terms. I mean, they owed some obligation to Santan to cover some of those issues. They've been undermining the defenses. They've been arguing against their own client in their liability to Pinal County. I mean, that is not proper for an insurance company or a bonding company to do that. And I think that they put their primary interest, financial interest, at stake. They weren't interested in having the court determine the rights and obligations of the parties on the bond and the cancellation of those issues we're discussing this morning. Their interest was just going after Santan Borgata to collect ongoing bond premiums and making arguments against them on behalf of the bonding, Pinal County to collect the premiums. And I'm out of time, Your Honor.
Good morning. Matt Sloan, appearing from the law firm of Jennings, Houghton, Cunningham on behalf of the plaintiff appellee Bond Safeguard Insurance Company. Our position is this is a simple breach of contract case. Appellants make all kinds of arguments. Whether they have any validity or not, they don't apply, and they're just not relevant to the underlying breach of contract claim. What we've got here is a situation where Santan Borgata just acquired some property in Pinal County and wanted to develop it. And they went to the county and asked for permission to develop it, to get permits, to get a plat, and the county agreed that they would issue a plat to Santan. But one of the conditions, which the county is allowed to require by law, is that they would have to post a financial assurance to protect the county against the risk that the development would be not fully completed, that the improvements, specifically here sewer and water and roadways, would not be completed. The county wanted protection against that risk. And so in order to get protection against that risk, Santan Borgata went to Bond Safeguard and said, will you agree to issue bonds on our behalf in connection with this development that we're doing? Bond Safeguard, after doing its underwriting and determining that the risk to it was worthwhile, said sure, and had Bond Safeguard and some of its principals and other entities execute a general agreement of indemnity. A couple days later, Bond Safeguard issued the bond in this case for $3.6 million, naming Pinal County as the obligee. And the principal was Santan Borgata. And the point of the bond was to protect the county in the event Santan Borgata could not or would not complete the required subdivision improvements. In other words, Bond Safeguard was stepping in to provide the county with protection against the risks that it perceived it had in connection with the development of this subdivision. Now, there's no dispute here about the execution of the general agreement indemnity or its terms. There's no dispute about the bond being executed or the bond's terms. There's no dispute that premiums were due annually, and in fact, Santan Borgata paid annual premiums the first 2 years, roughly $63,000, which I believe is 1.75% of the face amount of the bond, and that's generally how bond premiums are calculated on an annual basis, depending on the face amount of the bond. So premiums were paid for 2 years, and then Santan lost the property to foreclosure. They contend two things essentially: one, that they could cancel the bond, and two, that the bond was somehow discharged by operation of law. I don't think either of those arguments are right. But even if they are, it doesn't matter for purposes of the underlying breach of contract claim. So long, our position is, so long as Bond Safeguard had exposure, had risk, it was entitled to be paid premiums. And if you look at the terms of the general agreement of indemnity, the paragraph relating to payment of premiums, it specifically requires that the indemnitors pay premiums and charges, and I'm paraphrasing, until the company shall be discharged and released from any and all liability and responsibility upon and from each such bond, and until they deliver to the surety competent written evidence satisfactory to the company of its discharge from all liability on such bond or bonds. So that's their obligation, to pay premiums until the surety, the bonds issued by the surety, are discharged and they provide written evidence of such discharge. So now we get to talk about the bond and the cancellation provision, or lack of a cancellation provision. The bond is pretty clear also. It requires that the surety is on the hook until Santan Borgata completes the improvements, or if they complete the improvements, it will be void. Otherwise, it shall remain in full force and effect. And to the point the court made earlier, the contracts between the party are very specific on when the bond can be terminated. It can only be terminated by Santan Borgata when they complete their contractual obligations to the county. Otherwise, it remains in full force and effect, such that the county can make a claim on the bond if it chooses to. Now, in this particular case, the county did not make a claim on the bond at any point in time prior to Judge Anderson discharging the bond on February 28th of 2013. But the county certainly could have done that. That's the risk that Bond Safeguard was under during the time that they were obligated, Santan Borgata was obligated to pay premiums. This is not a theoretical risk, it's a real risk. And I'm currently litigating two cases, one for Lexon, which is Bond Safeguard's affiliate, in federal court, and one for Insurance Company of the West in state court, both involving a county in Arizona, involving two properties, both of which were lost by the original developer to foreclosure. In one instance, it was lost to the lender, and the lender now owns the property. In the other instance, it was a third party purchased the property at a foreclosure sale. In both of those cases, one, there was no development done at all, none of the improvements. One, some of them were done. In both cases, the lender in one and the subsequent developer in the other contracted with the county and entered into agreement with the county whereby the county has now sued Lexon and ICW to recover the bond proceeds for the benefit of the lender who now owns the property and for the benefit of the third-party developer who now owns the property. It's a real risk. It happens all the time. And so that's the reason why bond premiums need to continue to be paid, is because of the risk that continually exists. Even if all of their arguments are correct that they're making, none of them support the positions they've taken, which is they could cancel the bond. They haven't cited a single case where any court has ever ruled that a principal could cancel a bond that was issued for the benefit of someone else. It's because there is no such case. It doesn't make any sense. Common sense would dictate that the whole reason, as you noted, that the bond exists is to protect the county from exactly what happened here. It can't be a situation where they can decide they don't want to develop it anymore or they've lost it, and now they're going to deprive the county of the very benefit of their bargain. Similarly, all the cases that the appellants have cited with regard to situations where a court has ultimately determined that a surety is not liable because lots haven't been sold or improvements haven't been started, those are interesting arguments. They're arguments that Bond Safeguard could have made, potentially, if a claim was made on the bond. There are also arguments that the appellants could have made when the county initially refused to discharge the bond. They could have sued the county and required the county or made those arguments. But none of those cases say that when you lose the property, the bond is discharged. None of those cases say that. They all looked at the specific factual situations in those cases relating to the language in the bond or the underlying agreements, and the court in those cases made determinations. And there are other cases, and we've cited a couple of them in our brief, where the courts have gone the other way and said, no, the surety is going to be responsible. Again, I don't think those cases and those rulings are relevant to what we're talking about here today. What we're talking about here is a contractual relationship that involved the allocation of risk. The county agreed to allow Santan Borgata to develop a property. In exchange, they needed to provide insurance, which they got from Bond Safeguard. We agreed to be responsible and on the hook for $3.6 million worth of subdivision improvements, and the benefit of our bargain was that they would pay premiums so long as we carried that risk. And we carried that risk up until the time that Judge Anderson discharged the bond in February 2013. For those reasons, I believe it's clear that they're entitled to or obligated to pay those premiums up to that point in time. None of the cases that they've cited, none of the arguments that they've made, I believe, change that simple analysis. And to the point about making contrary arguments, we were never suggesting by any stretch of the imagination that we wanted the county to make a claim. We were always just simply arguing that we have risk, and while we have risk, you have to pay premiums. That's the contract that you entered into.
Is it fair to say, under the bond, that the county, regardless of the trustee sale, regardless that there were no lots sold, no construction commenced, could have called that bond?
They certainly could have made a claim with the surety for the bond, and the surety could have either denied the claim and given reasons for doing that if they believe that they had grounds to deny it.
And that's the liability that you faced.
That's the liability.
The county would do that.
Would do that. And ultimately, if we were successful in asserting some of these arguments, had the surety chose to do that, no lots were sold, there are no citizens out there who could be harmed. The purpose of the statute in Arizona that was discussed in the Ponderosa case, the purpose isn't going to be served by allowing the county to call the bond here. Could we have made those arguments if the county made a claim? Yes. Would they have been successful? I don't know. Maybe, maybe not. But in the meantime, we would have had to incur expenses internal expenses to process the claim, to analyze it, external expenses and costs to hire counsel to defend any action that would be brought by the county. And those are the risks that we agreed to undertake on behalf of Bond Safeguard.
Do you ever, in these situations, this is a general question, where you have a developer that they've lost the property in a trustee sale, they never sold any lots, they never commenced any construction, you've got the bond, you've got the liability out there, you go to the county and ask them to discharge the bond, and they refuse to do so. To protect yourself, do you ever file, I guess it'd be a combination declaratory action, mandamus action, to get them to release your bond?
I have not, but I mean, that has happened, but our position is that the onus is on the principal to do that. You know, that's their obligation. They have the contractual relationship with the county. We don't know necessarily what's going on. We don't know that they've all of a sudden lost the property foreclosure. We're not kept in the loop on that. We're not getting notifications. We send out premium notices. The first time in this instance we had any inkling that something was wrong was when they refused to pay the premiums when the agents contacted them and said, you know, you paid 2008 to 2009, you paid 2009 to 2010, we sent you an invoice for 10-11, you haven't paid it. And they had several conversations with the agent. They refused to pay, and that's when Bond Safeguard first became involved and got involved in the investigation to figure out, well, why aren't they paying, what's going on. And contrary to what Mr. Ducharme said, there actually is correspondence that I believe is in the record from Bond Safeguard where they specifically outlined their legal position as to why they could not cancel the bond.
Yeah, I'm just generally curious. Do you have bonds sitting out there on undeveloped land for 10, 15, 20 years? Nothing, the county never discharges it, and developers are just paying premiums?
Sometimes, usually what happens is the developer goes bankrupt and the developer is defunct and there's no one for the surety to turn to. One of the cases I'm involved in now with Insurance Company of the West, not only is the developer defunct, all of its principals are under federal indictment. There's no remedy for the surety. We're defending the case. All of our indemnitors have no money. If we have to pay out on the bond, that's going to be on us. If we defend the case, that's on us. And so premiums haven't been paid for a long time. We're not suing for the premiums because there's no way for us to recover because every entity that we had as a principal or an indemnitor is no longer in existence. And the bond by its terms remains in full force and effect. Now, is that a good idea? I don't think so. And I mean, I've certainly had those conversations with my surety clients about, you know, the language of the bond. And I'm not sure in this particular case who drafted this bond. But in the other cases I'm litigating, those are county required bonds. They're part of the county subdivision development code, and it's a specific county bond. I can't tell the court here whether this bond was drafted by Bond Safeguard or was a bond form that was required by the county.
It was mentioned that this is the indemnity agreement, the GAI, was a form agreement. Judge Thumma was asking these questions. Is it outside the pale of negotiations between a developer and a bond company to have provisions for cancellation of the bond if the property's sold and there's no construction? Or
no, there certainly can be, and Your Honor was right. There are riders that are sometimes executed, yes, in connection with the bonds. A lot of times it will be, you know, where you have a principal who's doing multiple projects, and they maybe have a new project they want to do that's very large, and they want some indemnitors to sign up, additional indemnitors to provide the surety with comfort. And so they'll do a rider, for example, for the new indemnitor saying, your exposure is limited only to this new project. That's the extent of your liability. And there are other riders that would have other limitations that can be negotiated by the parties.
One final question. Do you find it disturbing that I'm so interested in these bonds?
No, I know that you were involved in the Ponderosa case, and so I understand that this isn't your first.
Oh, I'm just teasing you.
We find it disturbing.
They find it disturbing. I'm finding it disturbing myself.
Actually, you know, I'm excited because most people don't have an understanding of surety bonds at all, and when you try to explain it to them, they're not interested, and it's very confusing, and they just sort of roll their eyes. So, the extent that the court is interested in hearing more about surety bonds, are there any other specific questions? No, I just say that, you know, all of the arguments, again, even if the court were to decide today that we think that their cancellation was valid, or we think that by operation of law the bond was discharged at some point in the past, that still does not relieve them from their obligation to have paid premiums while we were still at risk. And frankly, from the surety standpoint, if this court were to issue an order like that, a ruling, a reported decision that says that upon losing the property, the bond is discharged, my surety clients would be jumping for joy. But that's not the law. It's not appropriate, given the purpose of the bond to protect the county and its citizens.
Thank you.
Thanks.
Thank you both for your arguments. We will take this matter under advisement and issue a ruling in due course. And at this time, the court stands adjourned.